Good afternoon and welcome to another session of Ask Judge Carol Live, where I am on a mission to empower lives through education about the law. Today's topic is going to be on powers of attorney, and this has been motivated because I've had a few people asking me questions about the effect of a power of attorney in certain family circumstances, and I thought that this would be a good opportunity to address this topic. So, what is a power of attorney? That's the obvious question. And a power of attorney is simply a legal document that authorizes one person to represent another person to carry out your wishes or decisions or manage your affairs. So you can think of it as, so when you hear the word power of attorney, of course, the term attorney is in there, which you would be familiar with if you have an attorney or a lawyer representing you. And they would be a legal representative who would carry out your instructions in matters of law. So a power of attorney is given by what we call a donor to your attorney in fact. So they carry out your instructions in relation to business, financial affairs, property matters, and that kind of thing. So it's different from your legal attorney, your attorney at law. They are your attorney in fact. There are two types of powers of attorney, or two types of a power of attorney. One is what I would call a regular power of attorney. It would be given for a particular purpose and or for a particular period of time. And then you have an enduring power of attorney. And the Local Powers of Attorney Act of the Bahamas it actually covers both situations. So for a regular power of attorney, you will, the document is drawn up, it is signed by you as the donor, and then there is one witness. Normally there's a witness to the document. In the case of an enduring power of attorney, the formalities are similar, but the registration or the recording of the documents differs. So a regular power of attorney can be recorded in the Registrar General's Department. And this is useful because if someone is carrying out your instructions, then persons who are dealing with them, for example, in property transactions or financial transactions and so on, it's good to be able to demonstrate that that document has been recorded with the Registrar General's Department. In the case of an enduring power of attorney, that document, to be valid, must be lodged with the registrar of the court. And there's an office that you would go to there for an enduring power of attorney. And what that one is, so that's a little bit different from the regular power of attorney. An enduring power of attorney is one where you don't need them to act on your behalf immediately. With a regular power of attorney, you're giving someone, usually it's for a year, for 6 months, or it's for a particular purpose. Let's say you're going to be away in university and there's a case going on and you need someone to represent you. You would give them a power of attorney to act in your stead for that particular purpose. The enduring power of attorney is one that you prepare, so it's in the event that you become incapacitated, then they have the authority to manage your affairs on your behalf. Now, this brings up a key point. This distinction brings up a key point, an important point with powers of attorney. So the person who is giving the power to the donee, so the donor who's giving the power, they have to have mental capacity. They have to understand what they are doing. And as they say, they have to be compos mentis. They have to be in full possession of their faculties when they are doing it. And if something happens and the person with a regular power of attorney and the donor, the person giving it, loses that mental capacity, then the power of attorney then becomes invalid. So by operation of law, if you lose mental capacity after you've given a power of attorney, then it becomes invalid. However, in the case of an enduring power of attorney, it's given while the person is aware and fully functioning. However, it is designed and intended so that if something happens and you become incapacitated and you become mentally incapable, is what the term is in the Act. If you become mentally incapable, then that's when that power of attorney kicks in, the enduring power of attorney. So it's, in a way, it's kind of like the reverse situation. So if you know that, so if you're going to have a medical procedure and there's a risk perhaps that you may not recover your faculties, you may recover from the procedure but be incapable after the procedure, you may create an enduring power of attorney. Or for any instance where you think that end of life's kind of circumstances where people think, okay, if I become a vegetable, if I am unable to act on my own behalf, if I become overtaken with a disease that doesn't allow me to function mentally, but I still need my affairs to be carried on, that's when you have an enduring power of attorney. So that's why it's important, and the law requires that it be registered. It has to be deposited in the registry. And the Act says that no enduring power shall be valid unless it is deposited in the registry. So enduring power of attorney deposited in the registry of the court. Regular power of attorney is recorded. It's good practice for it to be recorded at the Registrar General's Department. So I touched already on the formalities. It must be signed and sealed by the donor. So normally it's drawn up in a lawyer's office. It has to be witnessed by one person. And then, and in the case that the donor has a physical incapacity, meaning that they're unable to write their name. So as you can imagine, sometimes a person is fully aware, they're not suffering from any mental incapacity, but physically unable to write. If you've had serious an accident and you can't use your hands. For whatever reason, you can't use your hands. Whether you've had an accident or whether you're just simply in that particular physical condition, then if you cannot sign the paper yourself, the law says there must be two other persons as witnesses. So if you can sign, you need one witness. If you cannot sign, you need two witnesses. And both of these are in the cases of regular powers of attorney. So I'm going to run through a couple of examples of recent cases from the Bahamian courts where a power of attorney was used, just to highlight the illustration of, why you would do one, why someone has given another person a power of attorney. So there was a case, Mackenzie Monroe and Mackenzie Taylor versus Moss. These are published cases from the Supreme Court website, Bahamas Judiciary website. So that's why I'm calling the names of the cases. So they're actual cases that you can research. And they're public cases, public documents. So in that particular case, there was a property owner, and it doesn't indicate where she was, but it seems from reading the case that she probably lived either outside of the Bahamas or potentially even on a family island, but she wasn't present and able to attend all of the court hearings and the court cases and so on. And in that case, she didn't bring the claim herself, but her attorneys, under a deed of power of attorney, did, suing a neighbor for trespass or encroachment. So the power of attorney, the illustration here is that the power of attorney lets someone else step into your shoes to protect your property interests and bring or defend legal proceedings on your behalf. So it's useful for if the owner is, the property owner is elderly, lives abroad, or is unable otherwise to manage to attend court. Then here's another case, the case of Keswani versus Hepburn, a case involving a claim regarding some diamonds. In that case, the claimant was represented by different people who held powers of attorney for him. First, his lawyer was actually appointed as a power of attorney to stand in his shoes to represent him in the litigation. And then another business partner was appointed after the attorney was no longer able to continue in the power of attorney role. So this case illustrates that a power of attorney is commonly used for ongoing business management and representation, and again, to bring litigation on behalf of a business owner. Then there's another case where a family member is acting for an heir in respect of a probate dispute. So in that case, Joseph Moxey held a deed of power of attorney for Marquette Knowles Brooks, the deceased's heir apparent and biological daughter. And Moxey used the case to apply for letters of administration on behalf of the daughter. And so this is an example of a power of attorney being used in the probate process itself to represent an heir and a beneficiary who can apply for letters of administration, but they lived outside the country, so they appointed someone to make the application on their behalf. So all of these cases show powers of attorney being used for ordinary, legitimate purposes: property management, business administration, litigation, and estate representation. So these are good examples for you to get a hold of to say, okay, this is why I would use a power of attorney. Now, on the other side, sometimes people have complaints, and I started out by saying there were a couple of cases where people had reached out to me asking about the effect of a power of attorney in a particular situation that affected them. So here's a case where Gerald, not his real name, but he wrote in to me and said, my sister obtained a fake power of attorney and is keeping me from seeing my mother. She filed a false abuse case against me, and now I'm technically homeless. So the first point is, which you may gather from the illustration, the explanation that I've given before, the power of attorney generally does not give your sister the right to isolate your mother or prevent you from seeing your mother. The power of attorney would have been given to the sister for the purpose of managing affairs, not for controlling your mother's movements. So that's not what the power of attorney is for. This raises really questions of the mental capacity of your mother. And as I mentioned before, if your sister was given a power of attorney to manage your mother's affairs, pay her bills, attend to property management, and that kind of thing, well, those are business affairs. It's not for saying who she could see or could not see. So this raises the question of whether or not your mother is mentally competent. And what you can do is you can check at the Registrar General's department and see if you find where that power of attorney was registered, and it may be a basis for challenging the power of attorney. You also, if there's a question, if she's mentally incapacitated, which is a really I'll say technical term. It's the term that's specifically mentioned in the Powers of Attorney Act as a basis on which, the court will act to determine that a person is incapable by reason of mental disorder from managing their property and administering their affairs. And so if that is the situation, again, it calls into question the validity of the power of attorney and whether or not perhaps it is no longer valid. And you will need to consult an attorney to determine if that is the case, what steps you need to take, or really as a basis for challenging this power of attorney. It may be that your sister is actually a legal guardian. If she has been appointed by the court and there's an order of guardianship, then that's a bit different from acting under a power of attorney. But certainly the question for using a power of attorney for preventing you from seeing your mother, that's outside of the scope of what a power of attorney is. And so those are some things that you would need to consider, Gerald, as to the extent of your sister's authority under the power of attorney, and perhaps take instruction as to whether it should be challenged, or simply approach your sister if, and get a copy of it to see what it covers and what it doesn't cover. It might be as well that the purpose that it was given for has also lapsed. So there's the question of mental capacity and competence, and then there's the question of the duration of the validity of it that you will need to consider. So I hope this session has been helpful. If you have a burning question that is, and you are concerned about which way to turn and you need some clarity and understanding about your next steps, then why not reach out to me at my website, judgecarol.net. That's www.judgecarol.net, and Carol is Carol, by the way. Or you can send a WhatsApp text to 242-451-4855. That's a WhatsApp at 451-4855. If you have enjoyed this episode, I'd love to also hear from you and send in your questions. I haven't seen any come in on today's session, but thank you to everyone who has tuned in, and I look forward to seeing you next week.